Laws and policies stop the spread of communicable disease, ensure that our food is safe for consumption, shape our transportation infrastructure, establish guidelines and codes for safe housing, and much more. Equally important, however, are our civil liberties. Public health officials and policymakers, those responsible for designing, implementing, and enforcing these laws and policies, must always consider the rights of affected individuals. How do public health departments balance the common good with the rights of affected individuals? Who has the power to create and enforce laws affecting public health? And what are the limits on that power? This video can help practitioners answer these questions in order to navigate their legal authority and the constitutional requirements related to everyday public health activities. First, let's explore who has the authority to create and enforce laws affecting public health. To answer this question, we must first look to the U.S. Constitution, which distributes power between the different levels of government, federal, state, and local, and provides a framework for balancing public health and individual interests. Under the Constitution, states have all of the powers not reserved for the federal government. This means that the Constitution gives states primary power over public health, including police power, which is the power to enact legislation and regulations that protect public health and safety and promote the common good. States can share police power with local governments. Some states, like Florida and Illinois, give local governments extensive authority to exercise police power. Others, like Arkansas, greatly limit the ability of local governments to exercise police power. And in some states, for example Texas, local governments can choose whether they exercise their extensive police power through local ordinances or follow the state's laws by default. When we say police power, we don't mean the power held by law enforcement. We're referring to the power held by government to take actions that protect the public, including public health powers. One well-known example of local police power is the power of local health officials to initiate isolation and quarantine orders. This is an example of the right of government to take action affecting individuals for the benefit of society. Other examples of government's exercise of police power to benefit public health include social distancing measures, public health surveillance, public health reporting, and epidemiological investigations. Courts generally defer to state and local governments' exercise of police power. However, the exercise of that power must be reasonable. How have courts defined reasonable? There are basic requirements, derived mainly from constitutional principles, for state or local exercise of police power. The exercise of police power cannot be arbitrary or oppressive. It must be rationally related to public health, safety, or general welfare. It also must be reasonably designed to correct a condition adversely affecting the public good, and it cannot violate state or federal laws or constitutions. Now that we've identified the source of public health authority, let's discuss some of the limits on this authority. To do this, we're going to dive a bit deeper into the Constitution itself. The first 10 amendments to the U.S. Constitution are known as the Bill of Rights, which guarantees the personal liberties to which individuals in the United States are entitled. Many of these amendments will be very familiar to you. The Bill of Rights includes the First Amendment, which grants freedom of speech and religion as well as the right to assemble. The Fourth Amendment, which protects against unreasonable searches and seizures. The Fifth Amendment, which will be a big focus for us in this video. It guarantees that individuals will not be deprived of life, liberty, or property without due process of law. It also guarantees the right to equal protection under the law and protects individuals against seizure of their private property without just compensation. Although the Bill of Rights is part of the federal Constitution, the 14th Amendment makes it applicable to states. For example, the Fifth Amendment guarantees that individuals will not be deprived of life, liberty, or property without due process of law. The 14th Amendment prohibits states from depriving individuals of life, liberty, or property without due process of law. Before passage of the 14th Amendment, which was ratified after the Civil War, the Supreme Court had interpreted the Fifth Amendment as applying only to the federal government. The 14th Amendment explicitly expanded the due process provision to apply to states. Due process is a central concept when we're talking about people's rights. Many governmental actions can affect individuals' lives, their liberty, that is, their self-determination, or their property, that is, their economic interests. The 5th and 14th Amendments of the U.S. Constitution both say that the government cannot deprive individuals of life, liberty, or property without due process of law. The 5th Amendment makes this a requirement for the federal government, and the 14th Amendment makes it a requirement for states. Due process of law. What does that mean? Due process looks at the fairness and reasonableness of government actions that deprive individuals of life, liberty, or property. In the next 2 slides, we'll discuss 2 types of due process: procedural and substantive. Procedural due process means that the government must follow certain procedures before interfering with someone's life, liberty, or property. A classic example is government benefits. If someone is receiving a benefit from the government, say disability benefits, the government cannot just terminate that benefit whenever and however it wants to. Before termination is allowed, the Constitution requires the government to provide written notice explaining that the benefits will be terminated and why, as well as an opportunity to challenge the decision to terminate. In contrast, substantive due process looks not at the procedures the government uses, but at whether the government has a good enough reason for depriving someone of life, liberty, or property. To decide whether a government's action is justified, a court will evaluate the relative importance of the individual and governmental interests at stake. The requirements for the government become more stringent as the individual interest at stake becomes more significant. In the context of emergency preparedness, the issues often involve personal autonomy and the right to make decisions about one's own body and movement. For example, to refuse medical treatment or to make decisions about where and when to travel or move around. The important point is that the government has a lot of power to take actions to protect public health most of the time, but it has to tread very carefully if it wants to enact a regulation that affects a core set of fundamental liberties. If you're interested in taking a deeper dive, we encourage you to check out our free online trainings, Public Health Threats in the U.S. Constitution and Public Health Law, Past and Present. This training is part of the Public Health Law Academy, which is supported by the Centers for Disease Control and Prevention, CDC. Our free and easy-to-use trainings provide a deeper understanding of the use of law and policy to improve population health outcomes. Developed in cooperation with ChangeLab Solutions, the online trainings offered by the Public Health Law Academy are essential for all public health professionals. To learn more, visit www.publichealthlawacademy.org. The views expressed in this video, including written training materials or publications, do not necessarily reflect the official policies of CDC or the U.S. Department of Health and Human Services. Nor does the mention of trade names, commercial practices, or organizations imply endorsement by the U.S. government. Like all materials associated with the Public Health Law Academy, this video provides legal information but not legal advice, and no attorney-client relationship is created. Please contact an attorney in your state if you need legal advice. Furthermore, the information provided in this video is for informational purposes only and does not constitute legal advice. ChangeLab Solutions does not enter into attorney-client relationships. And while every effort has been made to verify the accuracy of these materials, legal authorities and requirements may vary from jurisdiction to jurisdiction. The contents of this presentation have not been formally disseminated by the Centers for Disease Control and Prevention and should not be construed to represent any agency determination or policy. Always seek the advice of an attorney or other qualified professional on any questions you may have about a legal matter.